This is a civil case, and these are civil allegations brought in a civil complaint. They sound criminal, right? There's something in these allegations that resemble criminal sexual assault, sex trafficking, and other allegations in that world. My name is Dmitry Shakhnovich. I'm a criminal and civil litigation lawyer here in New York City. And beyond that, I also run a YouTube channel if you're interested in legal opinions, interviews with other folks in the legal space. In terms of the accusations levied against Vince McMahon, this is a federal lawsuit brought by somebody who was formerly associated with the WWE in some capacity of employment, claiming that Vince McMahon had effectively created an environment of sex trafficking and other allegations that involve that kind of conduct that is degrading, demeaning, and, for lack of a better word, horrifying if you look at some of the text messages. And the lawsuit involves an NDA that was signed by this woman who had not had some of the funds paid out under the NDA and is now suing, claiming all of these allegations took place involving Vince McMahon and other folks within the WWE world. And the lawsuit had just started, so there is no discovery. There is no evidence really in the case. Depositions have not taken place. Testimony has not taken place. But those are, in sum and substance, the allegations. So this is not a criminal case. This is a civil case. So in civil cases, there is no sentencing, right? Sentencing only happens in a criminal case upon conviction. In civil cases, there is a verdict on liability and then a verdict on damages in some form or another. Because in civil cases, you sue for money. You do not sue for anything resembling lack of freedom or the taking away of liberty. That is, in our system of justice, something that's reserved for the criminal courts. So if Vince McMahon drafted NDAs, prepared NDAs, had employees sign NDAs in violation of his agreement with WWE or any parent companies or other related companies, then he could be held potentially liable for that. But that is an issue between him and that entity. It is not at least directly related to these allegations. Now, the victim in this case tries to bring in one of these parent companies or other companies, and it turns out that they knew nothing about this and the NDA had nothing to do with them. They could possibly claim that Vince McMahon was an agent acting outside of his authority, and therefore their liability is limited. So that's a possibility, but that's really further exposure for Vince McMahon if that's the case. So an NDA is a contract. Generally, contracts must fit certain parameters in order to be deemed enforceable. There has to be consideration going both ways. It has to not be illegal. There are a million provisions that dictate enforceability of contracts. And if an NDA is in violation of one of those rules of law, then it will not be deemed enforceable. And so that is the issue with the NDA. So it depends. Again, this is not a criminal case. This isn't criminal conspiracy. So you won't have a position here where one of the co-defendants, quote unquote, flips and cooperates with the government, right? That doesn't really happen here. That's more for a criminal case. In a civil case, if John Laurinaitis is ever found liable for anything, then he can bring in Vince McMahon or try to assert that Vince McMahon is partially liable for some of the conduct that is described in those allegations. But this is not a criminal case. They can't flip co-defendants. But there can be testimony given by John Laurinaitis against Vince McMahon. And of course, if that's the case, that would be hurtful. So that's the main question in this case, right? Because while this is a civil case and these are civil allegations brought in a civil complaint, they sound criminal, right? There's something in these allegations that resemble criminal sexual assault, sex trafficking, and other allegations in that world. And if federal authorities find the need to charge Vince McMahon because they see that there is probable cause for a crime that was committed, then they will do that. And of course, to file a civil lawsuit, it's not difficult. You have to hire a lawyer who you would hope is acting ethically and prepares and files a non-frivolous complaint. And that's really all you need. Then there's service and discovery and things of that nature. The government is very different. A civilian cannot force the government to file a criminal case or to investigate or do anything, really. They can act as witnesses, they can file reports, they can make complaints, but that's all they can do. And the government has to decide whether or not there is probable cause to arrest somebody for a crime. And in a case like this, the government will surely dot its I's and cross its T's because it knows that Vince McMahon will defend himself, will hire high-powered lawyers and expensive investigators and things of that nature. And so it's possible, but let's not forget that even if Vince McMahon was arrested and charged and indicted for a crime, he would still have the presumption of innocence in his favor. He is entitled to that presumption. He will rely on that presumption. And in this case, he hasn't even been arrested, and we don't even know if he's being investigated. And it's important for us to keep that in mind. So that's possible, right? If more women come forward and file lawsuits, then it's possible that the allegations in one lawsuit may be used in another lawsuit. It also may further incentivize criminal authorities to pursue Vince McMahon because they may have stronger cases that rely on more than one victim. So for sure, it would not be a good thing if further lawsuits are filed. Doesn't mean that he would be liable for anything. It's not necessarily something that would lead to an automatic determination of wrongdoing. But of course, it's not good, particularly if there are similarities in the allegations, because then there's a real good argument in the law that you can bring in some claims into other lawsuits to bolster them effectively. And that would be problematic. So it's possible, right? Again, if there can be some showing that he wasn't just an independent agent acting effectively in such a way that intentionally victimized people without their knowledge entirely, there may be some vicarious liability there. But it's very hard to hold vicariously liable an entity for intentional acts, particularly such horrifying intentional acts as these, because you would have to show in some way that there was some connection between his employment and those acts in such a way that the higher-ups may have known about it. But if it was pervasive, if other employees were involved, if other involved parties had taken part, then you may have a stronger case. It depends on who they were. It depends on their duties in the company. It depends on what the internal processes and procedures are for these things. But it's certainly possible that a claim could be made out that a hostile environment was created and other folks knew about it. Thank you so much for joining me, everybody. I hope some of this information was informative and some of this information helped to have folks digest what are very difficult allegations and what are difficult processes in the law to understand. Please visit Sportskeeda Wrestling. And if you'd like to find me, again, my YouTube channel is youtube.com/DShackLaw. Reach out on social media or through email. Please feel free. I'll be happy to talk to anybody.